group that we have here tonight are all competitors or mostly?
I would say by and large, but we aren't limiting just to competitors, so we might
Okay,
have some other people are here for the edification.
great, great.
Fantastic. All right. Well, welcome everybody. I'm so glad you could make it. I'm really looking forward to the session today. We have a lot of great information because we have the fantastic Steve. Is it Gruber or
Gruber, yep.
yeah, the fantastic Steve, the one, the only. And Steve is a partner at NOD Law. He is a physicist by training who did his master's research at CU and at NIST. He went to law school at night while practicing at one of the largest law firms in the world, and since then has risen to partner at a patent and trademark focused Boulder area firm. So this guy knows his stuff, guys. Very, very fortunate to be able to pick his brain tonight. He has over 15 years of patent and trademark experience, and NOD Law does work for CU, CSU, and various local startups and mid-sized companies, as well as a handful of global leaders in their industries. So, from a young age, Steve loved to ask questions of his uncle, who was a NIST physicist. So runs in the family, huh?
Yep.
And when he was in college, his teammates called him Questions. That's a great nickname.
To
And
their
today,
chagrin sometimes.
so nowadays, it sounds like some of your best hours are spent listening to inventors teach you about their latest discoveries, like here at the New Venture Challenge, and then getting to help them tell their innovation stories to transform their innovations into assets, which is, I mean, what this is all about, right?
That's the hope. I mean, some people are changing the world. A lot of people are creating new companies to, make a lot of money, make a difference, whatever it may be. But this is definitely one of the pieces to get there.
Fantastic. Well, and nowadays you also like to spend time with family, go skiing, play ice hockey, and also do carpentry, huh?
Yep, yep. Fished up a cutting board just the other day for the wife's birthday. Working on some bookshelves in the office. Something to get the mind off of patent law because it's fun, but certainly um, sometimes you need a break from it.
Well, it's good to round things out, huh?
Yeah.
Awesome. Well, welcome, Steve. We're so glad to have you here tonight. Thank you so much.
Thank you for having me, and thank you everybody for being here. We've got a lot of people on the line, so I appreciate everybody taking the time out of their evening. I took a course when I was at CU that was an intro to IP for engineers. And the adjunct professor who later became my boss as a law student, he taught that course for 10 weeks. We'd go once a week, an hour, and I'm going to try to pack that entire lesson into 30 minutes tonight. So I'll probably be going quickly on some of the slides. I'm probably going to skip over some of it because there's just way too much to get through tonight. But if there is anything that is particularly helpful to what you all are doing with your own ventures, please don't hesitate to let me know. If people do have questions, do we are people able to unmute themselves, or what's that procedure? And Leah, you're muted right now.
Oh, funny, funny. That was on purpose, I swear. No, so people aren't muted necessarily, so they should be
Okay.
able to chime in with questions at any time.
Okay, perfect. And yeah, don't hesitate to interrupt me. All right. So I'm going to see if I can share this and get it going all at the same time. We'll do that screen and presentation. How does that look? Everybody can see the big screen?
I don't
No,
see it yet.
No? What what are you seeing on your end?
Your
Is it
lovely
one?
face.
Oh, here we go. How about now? There we go.
Yep, we can see that.
All right. Okay. So we're going to talk about patents. I've got about 20 slides here tonight. I'm going to try to get through that in 20 to 30 minutes and then open it up to questions. If we happen to have questions along the way, that's fine as well. But we're going to cover 5 big topics. What can you protect with IP? And this will kind of be a general intro to the various types of IP we can use. What do you get with a patent? Because we're going to be focusing on patents of the various types of IP, and then the different types of patents that you may want to utilize, the timeline of a patent, and some best practices. So first off, let's go through these different types of intellectual property. First off, patents. And one of the things to appreciate about this, people a lot of times come to me and say, I've got great results. Let's talk about the wonderful features that we market to our clientele. And typically that's different. Those are the benefits and the results, but not really the underlying how or the technology that we want to disclose to the patent office. So when you're speaking to a patent attorney, you're talking more about the underlying technology and less about the benefits and results. And what we're trying to cover is going to be products, subcomponents of products, software, the big asterisk there. And if anybody has questions about software, we can jump into that. And then in design patent land, you have aesthetics. And that may be relevant to anyone working in software because user interfaces are also protectable via design patents due to their aesthetic aspects. All right, you also have a world of trademarks, and this is where branding comes in. You can protect words, you can protect phrases, slogans, you can protect stylized lettering and slogans, and you can protect logos. So lots of different ways that you can protect your branding via trademarks. And then we have the whole area of trade secrets, which is everything that you don't disclose to the world, that you don't disclose to the US Patent and Trademark Office. These are things that you could keep close to the vest, like business methods, product formulations, manufacturing processes, algorithms. So for instance, Google and TikTok have their algorithms for determining what they're going to put at the top of your results. They may not want to tell the world what those algorithms are, even if they could get a patent on it. And then there are more less obvious things that you might want to go after to protect via trade secrets, such as customer lists, pricing, and once again, we see software again. So another way, if you don't want to patent your software, if you don't want to copyright it, which we'll get to on the next slide, you may want to just keep it as a trade secret or some combination of these. So lastly, copyrights. You've got books, you've got your web interface, the user interfaces on apps, on smartphones, the content of your website, including maybe just the photos that you've taken or the art that you've created. These are all protectable via copyright. And again, software. So you can see there's a number of different ways that we might want to protect software. That issue comes up a lot these days. You know, the VCs are putting a ton of money into software. It's low overhead. So we tend to see a lot of software clients come through the door, and there's just a lot of different ways to attack the protection of their intellectual property. So those are the 4 big types of intellectual property. I want you to be aware of that because even though we're going to focus on patents tonight, usually it's some combination of these 4 that will create the most value for your venture. And for some companies, it may be the trademark and the branding that's most important. For some, it may be the copyrights. Most companies, it is the patents, but I don't want anybody to get, pigeonholed into the idea that patents are the only way or the best way to protect your particular set of IP. So focusing now on patents, what is it that you actually get with a patent? It is the right to exclude. And it's the right to exclude from others from making, using, selling, offering to sell, or importing their product. And what's important to note about this is that it's not necessarily the right to sell your own product or to market your own product. It's merely the right to exclude others from doing those things. Your own rights to sell your product aren't really protected by anything other than your ability to avoid other people's patents. A patent is good for 20 years if we're talking about utility patents, which cover the function of a product, but they're only good for 15 years if we're talking about aesthetic protections in design patent land. And they're limited to the geography where you file. Oftentimes it's the US, but sometimes you'll pick out other foreign countries. You will pretty much never have worldwide coverage. It's just way too expensive to do that. Even the largest companies are picking out 10 different countries, Europe, the US, that sort of thing. And like I was saying, you do not have the right to necessarily practice your invention. Your rights are subject to the rights that others have. So for instance, if you are in AI land and you have developed a novel method for training an AI model, you can get a patent on that and you can exclude others from performing that same method of training, but you might actually infringe on somebody else's patent related to using an AI model. And because of that, you may be able to train, but not use your own AI model. So it's really important to keep this distinction between the patent's ability to prevent others from doing what you're doing from your own ability to practice your own invention. And why this is important as well is that you'll want to be sure that you're doing patent searching, whether your attorney is doing that, whether you're doing it through Google Patents. You really need to know what patents everyone else has on the table. Especially, as startups, you're going up against the Googles and the Apples of the world. They have big pockets. They have lots of attorneys. They have their eyes out. They are keeping their eye on the landscape and seeing what upstarts are coming along. And if you are stepping on their toes, they are going to come after you. And that's going to be a much bigger problem than whether or not you're getting your own patents. All right. And then let's talk a little more practically. It's going to be a valuation multiplier if you can obtain patents on whatever it is that you're doing. As an example, Google had a 10x multiplier on its revenue. Nest did when it was purchased by Google. And the same applies for any company that's going to go to VCs looking for investment, that's going to go looking for an exit. If you have more patents and a more solid portfolio of patents than the other companies that VC or that purchaser is looking at, you're obviously going to be a better target and you're going to be more highly valued. It's obviously also going to be a deterrent because your competitors are going to want to avoid your patents. But it's also going to create industry cred, right? If you can say we have one or more patents on whatever it is that we are creating, it shows that the federal government believes you are innovating, and it's a stamp of innovation that everybody has a reference point where they can say, yes, you have a patent. You are obviously more innovative than somebody that doesn't have a patent. And that may or may not be true, but that's at least what it's going to look like to the industry. And when you're marketing, when you're trying to sell your product, you're going to be able to say, we're patent pending, we have this many patents, whatever it may be. That's going to be a very nice feather in the cap. And lastly, not just as a deterrent, but if you do need to go after somebody and try to remove them from your market, you can always turn to litigation. All right, let's talk about the different types of patents. First being utility, which is going to cover functionality. And within that category, there's a provisional patent that we'll talk about. We'll talk about the non-provisional patent, which is also sometimes referred to as a utility patent. So it gets a little confusing there. But basically, you have a placeholder in the provisional, and you have the full-blown application as a non-provisional. And then if you do want to go international, there's a patent cooperation treaty application or PCT application that you'll most likely want to use in order to cut down costs and push out your cash flow, your expenditures until a later date. And your foreign applications, which will typically flow from a PCT application. And then on the aesthetic side, we have design patents. All right, so a provisional application is a very rough and dirty application. There are very few requirements at the patent office that dictate what you have to turn in other than a description of your invention. It may or may not include figures. They may be very rough figures. They may be a scan of something that you drew on a napkin. Ideally not, but worst case scenario, it can be that rough of a draft. These don't get examined. They merely give you a filing date to tell the rest of the world, this is the day that we came up with this invention. In the old days, it was all about notebooks and what date did you write down the invention and have two people sign attesting to your conception of the invention in your notebook. That's all out the window. Today, it only matters when you get your provisional or your non-provisional into the patent office. That's who wins the race. And another advantage of provisionals is that, again, because it's rough and dirty, you're not spending a lot of money with your attorney. You're mostly, in some cases, you can draft up most of the provisional and the attorney can finish it off. Ideally, you do want to have your attorney put a lot of time into that, but it at least allows you to get that filing date inexpensively, and you can file provisionals on a number of different inventions. And 12 months down the road is when you make the decision which of these inventions is actually worth investing in. Because when you file a non-provisional, that's when you're going to spend a lot of money with your attorney. And so you may want to go after 5 different inventions early on, and after some R&D, after some market research, you figure out that only 2 of those are actually going to be profitable, or maybe only 2 of them even work. So you'd basically abandon 3 of those 5 provisionals, and you'd put all of your investment into the 2 good ones when you convert those to non-provisionals. Some people like the approach of filing non-provisionals right from the get-go, but as you can see, then you've got to put all your eggs in that basket. You've got to make a huge investment up front, and if things change, that may not have been a great investment. So we tend to suggest file provisionals, give yourself 12 months, and then figure out which of those provisionals is worth turning into a real patent. Another advantage of provisionals, as compared to filing a non-provisional first, is that these don't necessarily become public knowledge. And a lot of you probably know that at some point your patent application is going to be published. The world is going to see exactly what you are doing. But that only happens after 18 months. So you have this 18-month blackout window. And if you file a provisional, let's say you file for 5 inventions, 2 of them are good, 3 of them are bad. And after 12 months, you say, let's not do anything further with those 3 that didn't work out. You abandon those provisionals, and those ideas, even those submitted to the patent office, will never be published. The world will never see them, and they will remain trade secrets. So even though you file a patent application, it doesn't mean that you can't still keep that idea as a trade secret. You're not going to do that with your best ideas. You're obviously going to want to move those all the way forward to a non-provisional and an issued patent and be able to enforce and license those. But it's just something to keep in mind that if you file a provisional, you're not necessarily going to have to disclose that to the world. All right. So let's say you filed your provisional or provisionals. 12 months have elapsed, and it's now the deadline to file your non-provisional. This is a much heavier lift. Your patent attorney is going to do a lot more drafting of the description. The figures are going to have to be formalized by a professional drafter, and there's going to be a lot more figures in a non-provisional than in a provisional. And most importantly, you're going to have to draft claims, or your attorney is going to be drafting claims. And the claims is a set of language that is super legalese. They can be difficult to read. A lot of times the language used doesn't make sense to engineers. It's maybe too abstract or not typical industry language. Whatever the case, the attorney is choosing a set of language that is going to best protect whatever your invention is. And a lot of time is going to go into crafting those claims. And in the end, even though you have 50 pages of description, 20 figures, it all comes down to those claims. When you go to court, it's those claims that dictate what it is that you own. And to visualize that, I've got this simple little Venn diagram where you can see our 50 pages of description, our 20 diagrams, covers everything under the sun, but what we really have protection over is some subset of everything that we've disclosed in the claims. So the claims are super, super important. And when your attorney comes back and says, hey, take a look at these claims, I need you to review these, that's where you want to spend most of your time. All right. If you want to go internationally, like I said, PCT application is a great way to do that. It's sort of like a provisional at the international stage, because you file a PCT application and you effectively have 18 additional months before you have to pick any of the countries that you want to go into, aside from Taiwan. Taiwan's kind of the big exception here. When you get to the 12-month date from your provisional, it's kind of PCT and Taiwan. Those are the decisions you're going to have to make. But assuming you've taken care of Taiwan at the 12-month date, or it's not an important nation to you, all the other countries that you're looking at will mostly be dealt with via the PCT. And you can make those decisions and that investment, which is going to be very large if you're trying to go for an international portfolio. All of those decisions can be made 18 months after the PCT is filed. So backing up, let's say you file the provisional today. 12 months from now, you want to go international, so you're going to file a PCT. It's in place of your non-provisional. It's effectively your non-provisional. And then 18 months after that, so 30 months from your provisional, is when you have to make all those national decisions. And it's a nice bit of time in order to potentially raise more funding or figure out which markets are going to be the best investment. Let's talk about design patents. For anyone that has some aesthetics in their product, whether this be the primary aspect of what you're building or just a subset of what you're looking to protect and where the value is, design patents will protect aesthetics. Now, there can be some overlap between functionality and aesthetics. So don't feel like design patents, can only be directed to dresses and cars and the shapes of a bottle. Sometimes the shape of something, the aesthetics of something, can also have functionality involved. User interfaces are a great example. You can see this figure here. This is a design patent. It has two different figures where they're effectively showing that touching the screen at different locations allows you to perform some sort of selection of an array of cells. There is functionality that they are trying to protect here, and they're doing it through the aesthetics of a design patent directed towards their user interface. As long as the aesthetics that you're going after are not purely functional, right? There's two different ways to achieve that functionality from an aesthetic standpoint, you're allowed to get a design patent on it. So don't rule out design patents as a way to indirectly get some functional protection in addition to your regular utility patents. All right, so just to summarize this, utility patents are covering functionality. The protection comes from the claims. So the words at the end of the patent, that's where the ultimate protection is. And they offer broader protection. A utility covering functionality will provide broader protection than a design patent, but you're going to spend more money and time getting it through the US Patent Office and the Examiner Court. A design will cover aesthetics in comparison to functionality. The claims, in a way, are the images themselves. The words of a design patent really don't mean much of anything. When you go to court, you're just comparing images to products. But it's narrower protection because the court is going to say, do these images, are they close enough to the product that is allegedly infringing that someone, an average consumer, is likely to be confused? That's a much narrower, more limited comparison than the functional comparison that takes place in utility patent land. On the other hand, it's going to cost you less money and it's going to go through the patent office quicker. So, pluses and minuses of utility and design patents. Timeline. One of the things that I want to point out first here is you can see this publication here in the middle. I was talking about that blackout window earlier. You file your provisional, and 18 months later is when publication occurs. So you have this 18-month blackout window, which gives you a sort of a trade secret period in which you've filed your application, you're planning to go through with it, but the world doesn't get to see your idea until 18 months after your filing. So that's a great opportunity to try and get ahead of anybody else before they start seeing behind the curtain of what you're doing. You can see in between your original filing and your publication date is that 12-month date when you have to figure out whether or not you're going to convert your provisional to a full-blown non-provisional application, or whether you're going to file a PCT application. And then once that non-provisional is filed at 12 months, there's going to be this period of a number of years where your attorneys and you are going back and forth with the office, with the US Patent and Trademark Office, and developing those claims, coming to an agreement. It's kind of a contractual agreement that says, this is the breadth of the invention that the federal government is going to give you a claim to. So that's the US timeline. And then to compare on the PCT side, this is if you're deciding to go international, you still have that same 18-month publication date. You still have that 12-month date when you have to decide whether you're going to file a PCT or not. And you're still going to see this period of argument and amendment with the international examiners. The difference here being the 30-month date. Like we said before, you file your provisional, and 30 months later, you're going to decide which countries you want to go into. So that national stage, the national stage applications are when you say Canada, Europe, China, counselor, these are the countries that we want to pay for. And so you have a nice bit of time there between 0 and 30 months when you can develop the funds to make those decisions and look at the markets. On the other hand, it's also a longer timeline. You can see it's 30 months before you even get into any of those nations. And then it's going to be another 2 to 5 years before you have issued international patents. So it's a bit of a long process. And sometimes, depending on the industry you're in, that may be too long for what you want to invest in. Let's do some best practices. And again, if anybody has any questions as we're going along, please don't hesitate to let me know. So before you talk to manufacturers, design partners, venture capitalists, or judges at any sort of a startup competition, you really want to have at least a provisional on file, ideally. You can't always do that, but that's, if I'm guiding you and you have the funding, that's definitely where you want to be. All of these, NDAs will only go so far. You have to enforce an NDA. There's holes in NDAs. There's loopholes. Um, they're only going to protect your idea as far as you're able to litigate and enforce that NDA against somebody. And by that point, they may have already destroyed your ability to file for a patent. If they've gone out and made that product or publicized it, put it into an article, you won't have the ability to file for your own invention. So while I do suggest you always have an NDA before making any of these contacts, just know that they're not the best solution. The best solution is to have a patent on file and to have an NDA. Now, VCs won't talk to you under an NDA in most cases. So, of course, try to get a provisional on file. But if you can't do that, the key is really to talk to those investors at a high level. And my guidance is really to show that you understand the market, you understand the industry, to show them your talent, your passion, your skill as a founder. Everybody's watched Shark Tank, and you probably have a sense of this. When you see somebody on there that's a kind of a striking personality in terms of their savvy, their ability to market a product, their ability to understand the market and know where money can be made. Those are the types of people on Shark Tank that really get your attention. You're like, hey, I would invest in that person. And it's not necessarily the product always. A lot of times it's the founder. And VCs are looking at that as well. So you don't always have to get into the technology. And in many cases, you don't want to. Especially if an NDA, well, you're not going to have an NDA in many cases, but even if you have an NDA, you still don't want to get into the technology if you don't have to, if you don't have a patent on file. Any questions on that? Talking to judges, VCs?
I don't have a question about that, but a little while ago when we were talking about the provisional and you holding on to it for 12 months before you file again, is there any penalty for like going or having the provisional and then not filing after 12 months? Or is it like if you're just not at the stage where you have the funds or the need to like get a like a further patent or a true patent, like is there any penalty or no?
So you're saying you filed the provisional and then you chose not to convert after 12 months?
Yeah. Or if you're still
Okay.
working on designs or something like that, or doing research, or don't have something worth patenting further, I guess.
Right, right. So not necessarily. Um, you can actually come back at a later time and file the same exact provisional. The world doesn't know about the first provisional that you filed, and the patent office isn't going to make it public. So you're allowed to refile. Where you might run into trouble is, let's say in that first 12 months, you started selling or you wrote an article. Those things could prevent you from refiling. Those could constitute prior art to your subsequent filing. But we've had situations where a client has said, this hasn't gone anywhere yet. We're not ready to invest further. Will you refile the provisional? And they've done it every 12 months. On this date, we're just refiling and abandoning the old provisional. And you can keep doing that. It's not ideal, but you can certainly get away with it.
And you can
The other,
file for the same technology, like it.
yeah, because again, the
Oh,
patent office hasn't published it unless you make the decision to convert the provisional.
okay, that makes sense. Is
Um,
there
the,
any?
the the risk you run is that
Yeah.
somebody else comes up with similar idea and they file for it. And now the patent office comes back to you when you eventually do pursue your filing all the way, and they say, hey, somebody came in between your two filings. Your old one doesn't count because you abandoned it. So in that case, you lose the race to the patent office.
But wouldn't you be refiling the patent for the same technology? Like, couldn't you hold on to it forever, basically, or what's the
Well,
loophole?
yes, except that you're now no longer the first one to invent that idea, according to the patent office, because they've seen another application come in before yours. Most likely it's not identical, but most of the rejections that we see are based on something that's similar and not identical.
Okay, that makes sense. Thank you.
Thank you for the question. All right, another thing that
Uh, I have a
yep,
question.
yes.
So after this provisional and when you go to PCT application, so is there a chance um, few countries will reject and you will get some countries will accept your patent?
So the question is, can you be rejected in some countries and not others?
Yeah, that's it.
Yep. Um, Usually what we'll see in terms of rejections in general, it's typically not a question of whether you're rejected and you give up and you don't get a patent at all. It usually comes down to, are you willing to narrow the claims sufficiently to get around prior art? And every country is going to find different prior art, and they're going to apply it differently. They all have different rules about how prior art applies and how what the rules are for obviousness. And so because of that, what you're typically going to run into is maybe you're getting a lot of pushback in China, and maybe we give up in China, but we get Europe and America, or maybe we get narrow claims in China and we get broader claims in Europe or America. It's usually going to be some combination like that, and it's usually going to be this grayscale of how broad, how valuable are the claims in a given country, rather than do you get a patent at all.
And what about so I'm working on an idea that is
Mm-hmm.
already patented in United Kingdom, but that patent don't have protection in the US.
Mm-hmm.
Then I just have a US patent, and after that file a PCT application rejecting United Kingdom. So will other countries will go through, or still will find a problem afterwards?
So I think you said you have a UK patent or just a
No,
pending
no,
application?
no, I don't have any patent. I'm just making
Uh-huh.
up a case. So let's say some technology is patented in UK, but that they don't have protection in the US and other countries.
Mm-hmm.
So if I have the same idea and file the patent for other countries, just getting rid of UK, will that sustain the case, or still find a problem there?
So depending on your timing, if you've already gone through the entire process of getting a patent in the UK, you've already missed your deadline to go international. So in that case, if you then tried to file internationally for the same idea, all you would get is the UK. Everybody else would reject you. They'd actually cite the UK application against you as prior art. So more likely what's going to happen is you'd file in the UK, and in parallel you would file in other nations, or you'd file a PCT application, because you can actually, right, the PCT can be based on a US case, or it can be based on a UK or a European case. Any nation that's a member of the PCT can support a PCT application. So most likely, it sounds like maybe you start in the UK, then you go PCT. 18 months later, you go into a number of other countries, Canada, US, Brazil, let's just say. And in that case, you'll probably get protection in all four of those countries, depending on what prior art the examiners find in each of those countries. Did that? Not sure if
Yeah,
I answered it.
yeah, I get the idea.
Okay.
Yeah, thanks.
Okay. Welcome. Um,
I also had a question.
yes.
So, as we all know, a patent lapses when the renewal fees are not paid on time. Um, and I'm wondering, if patents dues for 20 years, for example, were not paid, can I pay back the old fees and reclaim my patent as mine again?
Typically, no, if that's the fact pattern. Um, a lot of times what happens is that a client will say, I I inadvertently failed to pay the maintenance fees at 3.5, 7.5, or 11 years. And we would like to go in after the fact, file a petition, pay some extra fees, and we'd like to file the renewal late. It was a mistake. That's typically what will happen in the situation that you're describing. Um, and technically, you have to prove to the patent office that it was an inadvertent error and that all of the time between when you were supposed to pay it and you found the error was minimized. You filed as quickly as you could after you figured out your error. If it was intentional, because market forces changed, you got new investment a few years later, you're not going to be able to declare or testify to the patent office that it was an inadvertent error. That failure to pay would have been intentional.
I see. And but what if you had um wild circumstances that have prevented you from getting down to business and paying these fees, and you just got extremely busy with life?
Um, I would probably couch it differently, but yes, that is the kind of situation that might lead to an inadvertent error. During COVID, tons of people were filing petitions. Some aspect of COVID prevented me from doing whatever it was I was supposed to do, whether it was a maintenance fee or responding to an office action. And a lot of those, most of those petitions are getting approved. The patent office does very little to actually look into those petitions. In 15 years of practicing, I've filed dozens for various reasons. And I've only once had the patent office come back and ask questions. Are you sure that was inadvertent? Only once.
Thank you.
Good question. All right, and anybody can interrupt, but I'll just keep going with another nugget that I love to give to clients because it's a huge cost saver, which patent attorneys at whatever it may be, $500 an hour, it's very expensive for us to do patent searching. And a lot of the low-hanging fruit, maybe 60 to 80%, depending on how good and dedicated you are as a founder, can be searched out on your own using Google. Google's got an amazing platform for doing patent searching. I do half of my own searching on Google versus on proprietary software. And it's super easy to use. It's got, it's natural language algorithm, just like doing a Google search. It has advanced searches that allow you to filter based on the type of invention via classifications at the patent office. It's got a great interface for showing you the description, the claims, and the figures, all in an easy to see layout. If you ever try reading a real patent that is published at the patent office, it's really hard. The figures are over here, the description's over here, the claims are way down here. You've got to print out multiple pages and put them next to each other, and it's pain. Google, it's all right where you need it. You can flip through figures while you're looking at the same section of the specification or the claims. It's just a great platform and way to do your own searching. And you don't have to be super savvy to find a lot of the low-hanging fruit. The difficulty does come in because patent attorneys will often use language that maybe is not industry standard. And so in that case, Google's going to miss, those are the situations where you really want your patent attorney to hunt down those harder to find references. But it's at least a great place to start if you have, your CTO, or you have some engineers that you can put on the task. It's really a great use of internal time, and a great way to come, when you do meet with your patent attorney, you can say, look, this is the prior art that we found. And it's really a great leg up for enhancing the investment that you're going to make in your patent attorney. Another thing that comes up a lot, everybody's bootstrapping, everybody's running 100 miles an hour, and it's hard to dot all the I's. But in your employment agreements, make sure that everybody is assigning their IP, all types of IP, to the company. If it's your first employee, if it's your loan partner, it doesn't matter. You don't want any individuals owning IP. You want the company to own IP. This is one of the biggest headaches we have to deal with, is when clients come to us and say, we didn't have an agreement in place, we just didn't get to it for a few months, and somebody comes up with an invention before that's in place. And now what do? You're basically in a negotiation with your partner or one of your employees or a contractor for this pivotal IP, which may be jointly owned by multiple people, but unfortunately not the company. And you could spend a lot of resources fighting for that IP within your own organization, especially when somebody leaves for one reason or another. So one of the first things you should always do is get solid IP assignment language into your employment agreements. All right, 3 big takeaways. We've got various tools we talked about at the beginning for protecting your IP. I really want to stress the use of provisional patents. And just remember the various ways that patents add value and help you win market share. So we've got obviously patents, but don't forget about trademarks, copyrights, and trade secrets. And some combination of those is ideal, but in some cases, maybe your company is best protected merely by focusing on the branding and focusing on trademarks. Maybe that's where your investment should go. In other cases, it might just be copyrights, or everything needs to stay in trade secret land because, maybe it's software and things are moving so quickly that it doesn't make sense to spend 3 to 5 years getting a patent. Maybe everything should remain trade secret. Maybe it's so difficult to reverse engineer your technology that you're not worried about anyone figuring it out or discovering it on their own. Another great situation where maybe trade secret is better than having patents. So don't forget about those 4 different tools for protecting your IP. On the provisional side, just remember this is a really low-cost way to get your idea on file. You can abandon it within 12 months and the world won't know what that idea was. It'll stay a trade secret, but at least you will have that filing date. And if anybody else in the marketplace is trying to go after a similar idea, you have inexpensively found a way to beat them to the patent office. And then 12 months later, you have hopefully a larger market that you can rely on, and you have more investment so that you can focus on a more full-blown patent at that point. And don't forget the ability to file multiple provisionals and let some of them go. That's okay. Focus on the best ideas once you have a better idea of what they are. And then lastly, remember that patents, obviously they're a deterrence, but they also are going to help you in marketing, whether that's to industry partners, whether that's to your potential customers. And your portfolio doesn't have to be big. It just has to be well designed with strong, valuable claims that are focused on the product that you are producing. a lot of times companies may invest too much, right? They go after 10 different ideas, but there's really only one of them that is really the focus of the company. That might not be the best investment for that company. So a narrowly tailored, a properly tailored portfolio is the most important thing. On the other hand, for some people, numbers make a difference. So, and my goal with all of my clients is actually to keep them out of court. I don't really want anybody having to call a litigator and enforce their patents. I can add a lot of value and win a lot of market share without us ever having to step foot in a court. And hopefully that's everyone's goal. And hopefully there's no litigators in the audience listening. All right, I've got a few resources. I think we can send this presentation around to everyone. So if you want to take a look at these links, obviously Google Patents, super easy to find. But the USPTO, the US Patent and Trademark Office, has a number of free events every year. So that's something to look into for startups. You might find some valuable resources there. They are very engaged and focused on helping startups. And then on the branding side, there's a really good search interface at the US Patent and Trademark Office. So if you are starting to look at branding, do some of your own trademark searching. It's a great starting point to filter down and figure out which of your various brands might be the best ones to pursue. We had a few questions, but hopefully we have some more in the, well, it looks like we've got about 6 minutes left.
Yes, sorry. What is stopping someone else from jumping in if a patent expires?
Nothing. I mean, you probably heard in the generic drug realm, after that 20-year period, everybody jumps in. And so that's something that all of our clients deal with as well. The nice thing is 20 years is a long period of time. Most a lot of companies have either gone defunct or they've gone in a totally different direction. They've pivoted. If you're still making the same product after 20 years, you're doing really well. And you've probably sold to a much bigger company by that point as well. But yeah, once that patent is expired, everybody jumps in.
Yeah, I have heard that the EpiPen has expired, and I wonder if I can get in there before someone else, you know, or if they go back and file a patent again.
Well, and that's the thing to watch out for, is especially with a valuable product like that, they may lose the original patent to expiration, but they've probably jumped back in at the 5-year, at the 10-year point, and gone after advancements on the EpiPen, whatever that product may be. And those advancements are going to get 20 years of protection as well. So even if the broad claims are no longer valid, you still need to do your searching and make sure that they don't have something more narrowly focused that you need to avoid.
Yes, thank you very much.
Hey Steve, good evening. Thanks for going through this. Appreciate it. You briefly touched on the AI piece. In the recent times, what are some of the things that you have seen, especially in the AI space, that we need to be aware of and be cautious? Primarily, few things.
Oh, yeah, we've got a whole nother hour. We'd need a whole nother hour to cover that topic. Yeah, that's a big one. I honestly haven't had to deal with too much of it yet. I don't sorry, there's too many different directions to go with that one. With 3 minutes to go. But
No worries, I'll probably drop an email and we can
yeah,
chat
shoot
about
me an
it.
email and let's talk some more about that.
Sure. Thanks.
Hey Steve, I had a question. I was wondering how you know you've thoroughly conducted a patent search on your own if you're deciding to do it without paying a lawyer to do so. And with that being said, like, can you verify that you've done it completely with a lawyer, or how should I like go about that?
Great question. Great question. And it's a frustrating question for me to have to answer as well, because the answer is you can't verify. There are, I think we're in the 12 million series now of patents. There's no way, and that's just the US. There's no way to verify or even to be 95% sure that you've hit everything. The best you can do is when you start attacking a particular search from different directions, like maybe you're using different language, and you're starting to see the same results over and over and over again, even though you've attacked it from different directions. That's a pretty good sign that you're doing a thorough search. Beyond that, it's really tricky. Patent attorneys are notorious for using very unusual language to describe things. And so you inevitably run into the problem of you're using your set of language that you're used to in your industry, and you're going to miss the way that some patent attorney who either intentionally or maybe because they didn't even understand the invention totally has used a different set of language. So patent searching is one of the most difficult things that we do. And that's, like I said, you can get the low hanging fruit, but you're not going to get that last 30%, 40%. That's where your attorney comes in, the various searching abilities that they have. There's always going to be a risk of doing DIY, right? Whether it's electrical, whether it's the plumbing on your house, or it's your own patent. You're going to save money, but there's just inevitably risk there.
Yeah, for sure. Thanks for the advice. Appreciate it.
But don't avoid doing it. It's definitely something you should do. Just know its limitations.
Hey, one final question. So could you give a rough breakdown of like the cost for provisional and like full patent and what that looks like?
Sure. So very broad numbers, and these will vary depending on the complexity of the invention, the number of variations that you've come up with, the different, if it applies to different industries, if it's in a complex industry like semiconductor or pharmaceutical versus something simple like a consumer product. All those are going to cause these numbers to go in different directions, but roughly provisional, $4,000 to $5,000, non-provisional, another $10,000 to $15,000. Total budget to get a patent, $20,000 to $30,000. That's just a U.S. patent. International, you're pushing towards 100 and oftentimes over 100K, depending on how many countries you're going after.
Gotcha. Well, thank you.
And none of that includes the prior art searching that you should also be doing in parallel. Well, really good questions. Maybe one more quick one.
Hey Steve, I have an Indian patent like published, and it has been through the patent search. There were no hits. Similarity, it's a very novel thing. It has been published. It is under examination right now after being published in India. What way can I patent that for a US patent?
How long ago was that filing? More than 12 months ago?
Nope. It was
Okay.
just September last year.
Okay. Well, then you have until September of this year to file either a PCT application or to file directly with any number of other countries, such as the US. If you just want to go US, forget about the PCT. And that's, yeah, September would be your deadline, assuming there are no other factors such as sales, publications, those sorts of things could make it a little messier, but there's a grace period in the US, which complicates complicates things a little bit, but I would focus on that September deadline for getting into the US.
Got it. Thank you so much.
Good question. All right. Well, thank you, everybody. My email is up here on the screen, phone number. It will also be in the presentation that Leah will be able to send out. And if there are more questions or something comes up down the road before you all have your pitches or after you have your pitches or a judge gives you a hard time, whatever it may be, please feel free to reach out. Love giving back to the community and see you. So appreciate the time. Thanks, everybody, for coming out.
Thank you so much, Steve. Really appreciate your time today. Thanks everybody for coming. The recording of this will be posted online. I put the link in the chat, so if you want to check back in a couple of days, we'll have that up and ready to go there.
Thank you so much for this. Have a good one.